Well, it's your legislative governance doctor. Welcome to the Nigerian Legislative Clinic. Rivers State is burning again, this time. Second impeachment move on Governor Fubra. Well, is there really an impeachment in the Constitution of the Federal Republic of Nigeria 1999 as amended? The answer is no. And at Legislative Clinic, we help you diagnose, digest, and prescribe, solutions to our knowledge about democracy, constitutionalism, and legislative governance practices and procedure. Section 188 of the Nigerian Constitution provides for removal of governor or the deputy governor, not impeachment. If you go to the United States, you can have impeachment. It does not amount to removal. So to put it in context, what the Nigerian Constitution provides is removal of governor. But what are the processes and procedure in terms of both legislative practice procedure and the legal procedure as prescribed by the 1999 Constitution of the Federal Republic of Nigeria? If you go by the Constitution, Section 188 says that for Section 1881, anytime a notice signed by 1/3 members of the House of Assembly is served on the Speaker alleging that a gross misconduct has been committed by a holder of an office, this time a governor, or deputy, the Speaker has within 7 days to communicate to the holder of that office stating that there have been allegations of misconduct on his or her office, and also copies will be made available to members of the assembly. But what did we discover? Yesterday, we saw that it was even a motion that was presented, and the Speaker even attempted to put a question as to those in favor to say aye or nay. That is a breach of legislative procedure regarding removal of governor or the deputy. In fact, in line with Section 188, the House resolution to investigate such allegations are even without debate, as provided, I think Section 188 sub 8. And after the House are taking a substantive resolution, which is the second stage in removal process, if they are taking a substantive motion and the motion is passed by 2/3 members of the House, then it's transmitted within 14 days to the Chief Judge of the state at the request of the Speaker that the Chief Judge do constitute a panel of investigators to look into that allegation that have been made against the holder of the office. Now, the Chief Judge has the responsibility to constitute a panel of 7 men of distinguished character, people of integrity, who are non-partisan and who are not affiliated to any of the political parties in any way. This panel will now make a report to the National Assembly within a reasonable time that is not exceeding 3 months as provided. Now, if the panel report is negative, in other words, they found no merit in those allegations, what happens is that the House of Assembly will take no further legislative action on such a removal process. However, if the panel report is positive, in other words, they found merit to the allegations of gross misconduct so alleged by the petitioners, the House will then consider the report of that panel, and 2/3 majority vote will be required to adopt that report. And if 2/3 adopt the panel report to the fact that merit has been found on the allegation, the holders of that office will stand removed. And Section 188(11) says 10 and 11 provides that the court shall not entertain the proceedings regarding such processes, because these are legislative privileges that are constitutionally, legislature is constitutionally empowered to undertake. But what is even key? Procedure is very, very key. Procedure is key. Now, the Rivers State House of Assembly adjourned to 20-something of January. Within their standing orders, they have right to reconvene at any time. procedure for reconvening will also be looked at. So when there are procedural breach, you look at the materiality of those breach or otherwise. Now, it doesn't mean that since they started with a motion that the process is faulty, but it's just a way of educating Nigerians and including the parliamentarians and members of the assembly that there is a prescribed process that is required. And then when this petition has been taken, it will be approved in the vote and proceedings and what have you. But what is the issue here? Section 18811, I think, gave interpretation to what gross misconduct means. And interestingly, the definition of gross misconduct or interpretation of gross misconduct is in the opinion and discretion of the State Assembly. It is what they consider to be gross misconduct in line with the provisions of the Constitution that is gross misconduct, not what people say in social media or on WhatsApp platform or said emotionally or religiously or what have you. This is clear. We are looking at legislative practice and procedure. We are looking at constitutionalism. But what did they say the governor had done? If you look at Rivers State, and sincerely, if you look at Rivers State, they appear to have had only one substantive budget since 2023. The last valid budget of Rivers State government was the 2023 budget. They started having issues since 2023 into 2024, where the governor had to present the appropriation bill to a fractional state assembly, and all that are behind us now because the Supreme Court has said the democracy is on a tripod. You cannot proscribe the state legislature and say there was a government, that in those periods there was no government in Rivers. So, but honestly, we have to sympathize with the state assembly members. They are watching the governor announcing trillions, executing capital projects, and they never got to have the opportunity since assumption of office to actually pass their own budget, which is one of their key responsibilities. And we also have to sympathize with the governor, who lost also 6 months of his 4-year tenure as a result of the state of emergency that was declared by the president, and both government arms were suspended. But Section 120, 121, 122 is very critical. The governor must not spend the money that is not appropriated and approved by the State Assembly. An attempt to do so will amount to a slap on the Constitution, and that is an offense using the common language that is impeachable. Even though I had told us here, we don't have impeachment in our Constitution, what we have is removal from office. So no governor should be encouraged to keep spending state funds without following the due process of law. Rule of law is very central. And again, at the first attempt of the Rivers State Assembly to impeach the governor, it resulted in the bombing of the State Assembly building. And today they use a makeshift place. Now they are at it again. And people have said, oh, this is distraction. Agreed. Distraction to governance. The people of Rivers are the ones suffering the most because of this issue. However, constitutionalism must be allowed, rule of law must be allowed to take its part. The truth is, impeachment process or removal of elected official process is actually a political and legal process. In other words, there are both endogenous and exogenous factors that intercept to facilitate this process. So, politically speaking, every impeachment is stimulated by factors. So we can call the stakeholders who are responsible trying to destabilize this or the other. But again, calling on the president to come and intervene, who had intervened twice. Intervention of the personality of the president in constitutional and rule of law process is actually an aberration in democratic process. So what do we say? We have to have the governor obey the Constitution. He must make attempt to go and present the budget, and then we see how the State Assembly receive the budget otherwise. I know the fears, having followed political development in Rivers. I know the governor, if he goes to present the budget, they will rework the budget because Nigeria has a writing legislature which has the power to turn the skeleton of the budget, put it flesh and clothes for the use of governance. So he's worried that if he takes that budget, they will rework the budget and then send it back to him. And if he refuses to sign in line with the Constitution, after within 30 days, the State Assembly may override the governor's veto on appropriation bill, and that appropriation bill will automatically become an act, in which case the governor is bound to operate with the budget that has been passed and vetoed by the State Assembly. These are legitimate concerns, but governance and democracy must be allowed to thrive in Rivers State. The people are eager. They are waiting. We want the legislature to function. It's the fulcrum. It's the pillar of democracy. It symbolizes the presence of democracy. But representatives must not also appropriate institutional power to settle personal grievances. We maintain in this place that the most important agreement that anybody should honor and respect is the social contract between the government and the people of Rivers. Every other personal agreement can be settled at personal level. After all, FUBRA may have entered into those agreements as similar a FUBRA. Now, he is the executive governor of Rivers State. These are two different personalities. The State Assembly must also be respected and honored and allowed to perform their constitutional role. That is what we have for you today on Legislative Governance Clinic. All the things we're arguing and discussing about is written in this Constitution. It is this document that defines you as a citizen of Nigeria in section 25, 26, and 27. Tell us what you have learned on Legislative Governance Clinic today in the comment section.